of a hairdo. Look a little batshit crazy there, Gator. All right. We are back in the Tiki Lounge where Derek does some of his best work. And pardon me for my absence over the last few days. Needed to have a little coming to Jesus meeting. And the best way for me to do that is to get up there in the altitude, up in the clouds, and to kind of relax spiritually in the mountains. So that's what I did. And I'm back with a clear, clean head and ready to move forward. A lot of people are wondering what this is and the importance of it and why I would do such a thing. And, well, ladies and gentlemen, we only have three duties. Make an observation, create a record, and report or record it. All right, so that's what I did here. Now, this bit of paperwork will be going out even to Joe Bummer, aka Joe Biden, which, if the man has half a brain cell left to even read and comprehend what he's reading, far be it from me to make that determination. But just the same, this paperwork will go all the way there. It'll also go to the DOD, the Secret Service, State Insurance Commissioner. Everybody's going to have a little lovely copy of this. So what is it exactly? Well, the cover sheet tells you what all it entails. And I'm not done. I can still add to this. Oh, there's my lovely mailman. Maybe he's bringing me gifts today. General Durable Power of Attorney, Notice of Corporate Denial and Non-Corporate Status, License Grant Deed, Registration Memorial Outstanding Certificate of Title, and Memorial of Consumer Goods Primary Use of a 2004 Yamaha YZF-R 6 with VIN number. And people go, well, why do you use the VIN number? That's their VIN number. No. The VIN number is attached to a bond, ladies and gentlemen, okay? And that VIN number has value, and I've acquired that value, and that value is my value, okay? But until you put them all on notice, they presume and assume that it's all vested in their entity, which is all fine and dandy if you don't mind being a subservient slave to their municipality, their corporate construct. Remember, the constitutions are all banking charters, ladies and gentlemen, and the United States of America is not the only republic that exists. There's the Republic of China, there's the Republic of Russia, there's the Republic of Kazakhstan. Everything's a fucking republic. So this misnomer of people believing that the only republic that truly exists is in the United States of America is a misnomer. It's misleading. So, under the durable power of attorney, the general durable power of attorney, the special grant of authority replaces and suspends all prior powers of attorney by donor principal, all capital letter name, Derek Satan Gonzalez, Derek S. Gonzalez, Derek S. Gonzalez, Gonzalez, Derek Satan, all capital letters, or any such combination or representation of letters representing donor. Do hereby nominate, ordain, and appoint donee agent Gonzalez, Derek Satan, as called by parents Jose Gilmore Gonzalez and Lisa Wilder, in care of 1005 O Street, Ord, Nebraska, 68862, no phone number. Be my attorney in fact and executor general with authorities to wit. This power of attorney is effective immediately. Release of information I agree to authorize and allow full release of information by any governmental agency, business, creditor, or third party who may have information pertaining to my assets or income, to my agent named herein. Grant of general authority. I grant my agent and any successor agent general authority to act for me with respect to the following subjects as defined in the Nebraska Uniform Power of Attorney Act: real property, tangible personal property, stocks and bonds, commodities and options, banks and other financial institutions, operation of entity or business insurance and annuities, estates, trusts, and other beneficial interests, claims, and litigation, personal and family maintenance, benefits from government programs or civil or military service, retirement plan, taxes, and I grant my agent and any successor agent general authority to do all acts that I could do or do through an attorney, and grant my agent authority to exercise a presently exercisable general power of appointment held by the principal, and this power of attorney is not affected by lapse of time, subsequent disability, incapacity, or incompetence of the principal, and remains effective should principal suffer any subsequent legal incapacity, and grant of special authority. I grant my agent and any successor agent general authority to act for me with respect to create, amend, revoke, or terminate an inter vivius trust, make a gift which exceeds the monetary limitations of the Section 217 of the Uniform Power of Attorney Act or of the Nebraska Uniform Power of Attorney Act, create or change rights of survivorship, create or change a beneficiary designation, delegate to another person to exercise the authority granted under this power of attorney, waive the principal rights to be a beneficiary of a joint and survivor annuity, including a survivor benefit under a retirement plan, exercise fiduciary powers that the principal has authority to delegate, renounce, or disclaim an interest in property, including a power of appointment and a personal finances to withdraw and deposit funds from a bank account belonging to the principal, and to enter and remove the contents of all safe deposit boxes rented by the principal, to ask, demand, sue for, recover, collect, and receive each and every sum of money, debt, account, legacy, bequest, interest, dividend, annuity, and demand, which now is or hereafter shall become recovery thereof by legal process or otherwise, and to execute and deliver a satisfaction or release therefore, together with the right and power to compromise or compound any claim or demand, to borrow money and to execute and deliver notes with or without security, and to loan money and receive notes, improvements thereon. Notes with such security as attorney in fact shall deem proper. B, real property or any interest therein or any improvements thereon, to contract for, purchase, receive, and take possession thereof, and of evidence and title thereto, to lease the same for any term or purpose, including leases for business residence, to sell, change, subdivide, grant, or convey the same, with or without warranty, covenant, or restrictions. 2, hold on, gotta blow my nose here. Gotta love that. Oh, there we go. 2, mortgage, transfer, in trust, or otherwise encumbered the same, to secure payment of a note or performance of any obligation or agreement. C, personal property, to contact for, buy, sell, trade, exchange, transfer, endorse, negotiate, and in any legal manner deal in and with the same, and to mortgage, transfer, in trust, or otherwise encumber the same, to secure payment of a note of performance of any obligation or agreement. D, business transactions of any kind, and as the act and deed of principal to sign, execute, acknowledge, and deliver any deed, lease, assignment of lease, covenant, indemnity, agreement, mortgage, deed of trust, assignment of mortgage, or beneficial interest under deed of trust, subdivision or plat, extension or renewal of any obligation, subordination, or waiver of priority, bill of lading, bill of sale, bond, note, receipt, check, evidence of debt, full or partial release of mortgage judgment or other debt, and such other instruments in writing of any kind or class as may be necessary or proper in the premises, to do and perform every and all of any acts required, necessary, or appropriate to be done in and about the premises as fully to all intents and purposes as principal might or could do if personally present, hereby ratifying all that attorney in fact shall lawfully do or cause to be done by virtue of this general power of attorney. F. And authorize another person to exercise the authority granted under this power of attorney, and limitations on agent's authority. An agent that is not my ancestor, spouse, or decedent may not use my property to benefit the agent or a person to whom the agent owes an obligation of support unless I have included that authority in special instructions, except for any special instructions given herein to the agent to make gifts. The following shall apply. Any power of attorney granted to my agent herein shall be limited so as to prevent this power of attorney from causing any agent to be taxed on my income or from causing my assets to be subject to a general power of appointment by my agent as defined in 2038, 2041, and 2514 of the Internal Revenue Code of 1986 as amended. B. Agent is not required to be bonded per Title 26 U.S.C. 2032 AE 11. Successor nominee agent is Lisa Wilder Leach, biological mother, in care of 10050 Street, Ord, Nebraska 68862. Nomination of conservator and guardian. Should it become necessary for a court to appoint a conservator or guardian over my estate or guardian of my person, I nominate the following person for conservator and guardian appointment over my estate and person is donee or successor if donee is incapacitated at 10050 Street, Ord, Nebraska 68862. A copy of this instrument shall have the same force and effect as the original. And then, of course, it's signed and dated by myself and notarized and placed on the record. All right? So, there's no more throwing my shit out of the courtroom because, well, it's not a record. Well, I created a record. My record, I can testify with firsthand perfected knowledge, where any agent and agency, they don't have it. And they don't have power of attorney. And I'm going to have to see their delegation of authority, their warrant of attorney to attach themselves to my estate, or we got problems, right? The next thing on the list was notice of corporate denial and non-corporate status. We've been through this a couple times. You guys are wanting to hear it, to understand it. And again, it doesn't have to be done this way. It could be done in a lot simpler methods. But when you start to read a lot, you want to make your points, right? And you don't want to show your points of authority. Well, all my points of authority come from the Heavenly Father. I mean, there is no higher authority in the world, period. It just doesn't exist. So, no man created himself, thus all men are created equal. A whole lot of heat and pressure and love, hopefully, is what created you. Notice of corporate denial and non-corporate status. Let the record show with the knowledge of the facts, assumption and presumption may prevail unless rebutted or explicitly denied. I, this ass servant, do plainly state that ass servant is in no way to be considered, termed as, or thought as a person, legal entity, legal fiction, fictional character, or corporation of any form, with the knowledge that all such entities are not living, breathing, sentient men. Therefore, as servant hereby makes express and explicit claim and affirmation to the living, whose creator is as servant's heavenly Father, and express and explicit claim that as servant is not a person or any other form of a corporation. The word person is, according to several references and Title 22 U.S.C. 1621 definition for the purpose of the subchapter A, the term person shall include, and remember if it includes everything that it doesn't list, it excludes. So the term person shall include an individual, partnership, corporation, or government of the United States. The Federal Rules of Civil Procedure, Rule 52, applies in civil and criminal actions with equal force and effect because criminal is always civil in nature. No civil or criminal cause of action can arise lest there be a contract. See EADS versus Marx. There is always a presumption that a contract exists and that the responding party is a corporation. Under Rule 52, which is the same in all states as in the federal rules, the Texas Court of Appeals Fifth Circuit has ruled of the finding of facts by the court that the failure of an adverse party to deny under oath the allegation that he is incorporated dispenses with the necessity of the proof of the fact. Thus, a presumption becomes a finding of facts by the court unless rebutted before trial. Plaintiff plead defendant was a corporation. Defendant did not deny by verified pleading pursuant to TRCP 52 and 83 that it was not a corporation. Thus, such fact was established. Louisiana Revised Statute, Article 429, corporation existence is presumed unless affidavit of denial is filed before trial. A presumption is a rule of law, statutory or judicial, by which the finding of a basic fact gives rise to the existence of presumed fact unless presumption is rebutted. See Van Wart versus Cook. In the commercial law of all states, a presumption means that the trier, the judge of the fact, must find the existence of the fact presumed per Federal Rule Civil Procedure 52 unless and until the evidence is introduced, which would support a finding of its non-existence. Arizona Revised Statute, Title 47, Section 1201-31, presumption or presumed, means that the trier of the fact must find the existence of the fact presumed unless and until evidence is introduced, which would support a finding of its non-existence. Thus, this affidavit of non-corporate status is for the purpose of rebutting any presumption that the asservant is the corporation by whatever name or notation. Federal Rules Evidence, R301, Agreement by Acquiescence, Rule 301 of Federal Evidence, of the Federal Rules of Evidence states, a presumption imposes on the party against whom it is directed the burden of proof, see 556D, of going forward with evidence to rebut or meet the presumption. When the complainant is lodged by the government for a fine, fee, or a tax, all of which are revenue, they are imposed only on corporations. See Colonial Pipeline Co. versus Triangle. This asservant rebuts any presumption presuming that asservant is a corporation or general partner to any corporation. Where an asservant is not a corporation, he cannot appear and plead. When a person brought into court by its corporate name, its existence as a corporation is admitted. And I'm just going to skip over all these court cases that support this because there's a ton of them in the last two statements I made. Stating conclusions only is insufficient. It has been held that where the representative of a railroad corporation is served with process, he may plead in abatement in his own name that the corporation is extinct. Where the person is so served with that, he may by plea deny that she sustains any such relation to the corporation that authorizes the service of process on him or her. The Supreme Court did not grant corporate personhood to any state of the Union or federal government, and that this doctrine derives from a mistaken interpretation of a Supreme Court reporter's notes. See Santa Clara County versus Southern Pacific Railroad Company. No law has been passed by Congress granting that corporations under the Constitution should be treated the same as members of the living, breathing mankind. No court decision, state or federal, held that corporations were persons instead of artificial persons. And Santa Clara County versus Southern Pacific Railroad Company, the Supreme Court did not rule on the issue of corporate personhood. Railroad attorney Saunders and his two colleagues watched as Chief Justice Morrison Remick told Delmas and his two colleagues, the attorney for the opposing party, that the court does not wish to hear argument on the question whether the provisions in the 14th Amendment to the Constitution, which forbids a state to deny to any person within its jurisdiction the equal protection of the laws, applies to these corporations. We are of the opinion that it does. This written statement that corporations were persons rather than artificial persons with an equal footing under the Bill of Rights as humans was not a formal ruling of the court, but was reportedly a simple statement by the Chief Justice recorded by the court recorder. See Vermont Supreme Court Building, Volume 118 of the United States Reports, case adjudged in the Supreme Court at October terms 1885 and October terms 1886, published in New York in 1886 by Banks and Brothers Publishers and written by J.C. Bancroft Davis, Supreme Court reporter. Here is the often expressed understanding from the United States Supreme Court that in common usage, states employing the term person and corporation are ordinarily construed to exclude the sovereign man or woman. And that's Wilson versus Omaha Tribe, United States versus Cooper Corp, and United States versus Mine Workers. Additional research into meanings of U.S. citizens. The term citizen of the United States, as found in qualifications clauses, is properly construed to mean citizen of the state which are united by and under the U.S. Constitution. This construction, is reiterated in the following passages from words and phrases, to wit: citizen of a state within the Removal Act, 18 Stat 473, March 3rd, 1875, means of one of the United States, and the suits contemplated are suits between citizens of one of the states of the Union on one side and foreign states or citizens or subjects on the other. That's Roberts versus Pacific and A. Rye and Navigation Co. And that was held in 1903 in the Ninth Circuit Court. It appears to be in California. Here is often expressed understanding from the United States Supreme Court that in common usage, statutes employing the term person and corporation are ordinarily construed to exclude the sovereign man or woman. Wilson versus Omaha Tribe. U.S. Supreme Court in Luther versus Borden, 48 U.S. 112 LED 581. The government are but trustees acting under derived authority and have no power to delegate what is not delegated to them. But the people, as the original fountain, might take away what they have delegated and entrust to whom they please. The sovereignty in every state resides in the people of the state, and they may alter and change their form of government at their own pleasure. U.S. Supreme Court in Wilson versus Omaha Indian Tribe, 442 U.S. 653, 667, 1979. In common usage, the term person does not include the sovereign, and statutes employing the word are ordinarily construed to exclude it. A servant is not a United States person, United States resident, U.S. citizen, U.S. individual, U.S. corporation, or citizen subject to its jurisdiction. As such are words of art or terms of art. Nor is a servant a corporation created under the law of the United States or any state of the Union States, the District of Columbia, or any territory, commonwealth, or possession of the United States, or any territorial foreign state or country, public or private. A servant is not a resident of, inhabitant of, a franchisee of, subject of, ward of, property of, chattel of, or subject to the jurisdiction of the state of the forum of any United States corporate state, corporate county, or corporate city or municipal body politic created under the primary authority of Article 1, Section 8, Clause 17, and Article 4, Section 3, Clause 2 of the Constitution for the United States of America, and thereby not subject to any legislation created by or under the jurisdiction of any employees, officers, or agents deriving their authority thereof. Further, as servant is not a subject of the administrative and legislative Article 1 courts, nor bound by precedent of such courts created by the United States, given legislation enacted by Congress applicable to the inferior courts in the exercise of their power under Article 3 of the Constitution, cannot be affected by legislation enacted by Congress under Article 1, Section 8, Clause 17 of the Constitution. The District of Columbia Code, Title 11 at page 13, an officer, agent, shareholder, franchise, or fiduciary agent, surety, resident, inhabitant, or domiciled in any corporation. As servant does rescind, revoke, and cancel all of each of as servant's signatures on any and all forms, instructions, which may be construed as granting to the federal government or any other agency or department of the United States government created under the authority of Article 1, Section 8, Clause 17, and Article 4, Section 3, Clause 12 of the Constitution for the United States, authority or jurisdiction over as servant, for on the grounds of constructive fraud and non-disclosure of pertinent facts, as servant does also revoke, rescind, and make void ab initio all powers of attorney, conservatorship, guardianship, or receivership, whether in fact, by presumption, express or implied, or otherwise, signed either by as servant or any person or individual with or without as servant's consent. As such power of attorney may be presumed to pertain to as servant or as servant's person by, but not limited to, as presumed by any and all quasi-colorable government entities or corporations. As servant is not a vessel documented under Chapter 121 of Title 46, United States Code, or a vessel numbered as provided in Chapter 123 of said title. As servant does hereby cancel any presumed election made by the United States government or any agency or department thereof, presuming that as servant is or ever has been a citizen, alien citizen, or resident of any territory, possession, instrumentality, or enclave under the sovereignty or exclusive jurisdiction of the United States, as defined in the Constitution for the United States of America in Article 1, Section 8, Clause 17, and Article 4, Section 3, Clause 2. As servant is neither an enemy of the United States nor enemy ally against nor any corporation created under the either laws of the United States or any state of the Union States, the District of Columbia, Territory, Commonwealth, or possession of the United States, nor a foreign state or country, public or private. As servant's name is a private possession of as servant, and is neither given nor granted to any other without fee assessed. Nonetheless, as servant's Christian appellation is Derek Chaton of the House of Gonzalez, styled Derek Chaton Gonzalez, with location of domicile being where the living man stands on the land, in the land. And many be instantly noticed at non-domestic carrier route mail location 10050 Street, RRCO1, Ord, Nebraska, United States of America, addressing with the name particularly unique to as servant, but not affiliated with any corporate body politic near the same location, and is determined as complete, necessary, and sufficient identification evidencing as servant's neutral standing. Title 15, USC 1681H. These as servant supported, these averments supported by affidavit is not averred for the purpose of debating constitutionality or legality of the of the Communications Act of 1934, but rather to raise the specter, exposing the United States government lack of jurisdiction in these matters. A servant is not a pirate affiliated with or an enemy of any public or private corporation, domestic or foreign, but rather a servant is a neutral body. Any past or future reference to a servant's ex rel, any fiction referenced by any agency or its officer, is deemed defamation of character and false and misleading statements under Title 15 U.S.C. 1692E and 78 FF, and that may expose offenders or offender and all liabilities to good faith immunity waiver and their volunteering to litigation and or assessment in their jurisdiction within the Admiralty Title 28 USC 1333 or 1337, Bills of Lading Act, the Public Vessel Act, Foreign Sovereign Immunity Act, False Claims Act, Federal Arbitration Act, Declaratory Judgment Act, given that any of the facts or laws presented herein are not contrary to the Communications Act of 1934. All facts averred herein are, to the best of the ass servant's research and belief, whereby ass servant has not seen any facts or evidence that any of these herein averred facts, averments, have been determined to be frivolous, as determined by a court of competent jurisdiction where averred within their exact and proper context. These averments are technical facts that, under commercial law, must be point for point expressly rebutted with respondents sworn first-hand personal knowledge via counter affidavit with supporting facts and evidence in support thereof, all sworn to be true, correct, complete, and not misleading by misrepresentation of omission under respondent's full unlimited commercial liability to avoid nihil dicet tacit procurement acquiescence. Any statement or claim averred herein must be properly rebutted by facts of law or overriding Article 3 Supreme Court rulings, and shall not prejudice the lawful validity of other claims not properly rebutted or invalidated by fact of law. Therefore, an affidavit of truth under commercial law can only be satisfied, 1, through a rebuttal affidavit of truth point for point, 2, by payment, 3, by agreement, 4, by resolution by a jury under the rules of the common law. Further, a servant denies having or ever having had a birthday, but rather a servant does have a nativity upon the soil, of Arizona and the Republic thereof, and a servant does celebrate a servant's day of conception. A servant expressly avers that a servant is an adverse party ex rel presumed of corporation existence, and a servant does deny any allegation that a servant is incorporated, and the closing unrebutted averment underscored by a servant wet ink autograph and landmark imprints is a servant's express proof of the facts that a servant is the expression of the living God here on earth, as per the failure of an adverse party to deny under oath the allegations that he is incorporated with the necessity of proof of the fact. It becomes part of the official record. Galleria Bank versus Southwest Properties. Use, misuse, and abuse of words to change the meaning. Webster's 1828 dictionary says this under birth, which is B-R-I-T-H, all capital letters, which is one form of it, and the other form is all lowercase B-E-R-T-H. Birth, or birth, and born all come from the same root of to bear. When you look up birth, B-E-R-T-H, you find out that every definition has to do with ships. So our birthday is the day we were given a place within the maritime admiralty jurisdiction of the state. Webster's New World Dictionary of the English Language, 3rd College Edition, copyright 1988, page 132, birth, B-E-R-T-H, noun, for a position, place, office, job, etc. We perceive that this B-E-R-T-H is the office of person aboard the ship of state. A living soul has a date of nativity with life beginnings at the moment of conception, while on the other hand, a corporate soul has a date of birth, B-I-R-T-H, /B-E-R-T-H. There are only two birthday parties in the scripture, and in both cases, a man lost his head. At Pharaoh's birthday party in Genesis, the baker was hung, and at Herod's birthday party in the Gospel, John the Baptist was beheaded. So how did a Christian culture end up celebrating birth, B-R-T-H, days, birthdays, as is customary? Somebody had a plan, and that plan involved embedding a number, the number of the beast, into our conscience at a very early age as possible. The third birthday was mentioned in the Holy Writ. Note that the 666 talents of gold mentioned below did not include all that was brought by merchants' means. 1 Kings 10:14 and 2 Chronicles 9:13. Now the weight of the gold that come to Solomon is 1 year was 666 talents of gold. Wherefore I do inform the nice policemen, mobile revenue enforcement agents, peace officers, the bureaucrats, and de facto court system, and all other parties that may make inquiry, I, as I am, have no birthday, even backing that with no man can be compelled to incriminate himself. Memorandum of law and points of authority in support of non-corporate status as servant. Averments. The Federal Rules of Civil Procedure, Rule 52, applies in civil and criminal actions with equal force and effect because criminal is always civil in nature. No civil or criminal cause of action can arise lest there be a contract. See Eds versus Marks. There is always a presumption that a contract exists and that the responding party is a corporation under Rule 52, which is the same in all states as in the federal rules. The Texas Court of Appeals 5th Circuit has ruled on the finding of facts by the court that the failure of an adverse party to deny under oath the allegations that he is incorporated dispenses with the necessity of proof of the fact. Thus, a presumption becomes a finding of facts by the court unless rebutted before trial. Dr. Pepper Co. versus Crow, 621 SW 2D 464-465. Texas Appellate Waco, 1981, no writ. Plaintiff plead defendant was a corporation. Defendant did not deny by verified pleading pursuant to TRCP 52 and 83 that it was not a corporation. Thus, such fact was established. Louisiana Revised Statute, Article 429, corporation existence presumed unless affidavit of denial filed before trial. A presumption is a rule of law, statutory or judicial, by which the finding of a basic fact gives rise to the existence of presumed facts until presumption is rebutted. See Van Wart versus Cook, 557, page 2D, 1161. In the commercial law of all states, a presumption means that the trier of fact must find the existence of the fact presumed per Federal Rule Civil Procedure 52 unless and until evidence is introduced which would support a finding of its non-existence. Arizona Revised Statute, Title 47, Section 1201-31, presumption or presume means that their trier of the fact must find existence of the fact presumed unless and until evidence is introduced which would support a finding of its non-existence. Thus, these averments, averring as servants, non-corporate status is averred for the special purpose of rebutting any presumptions that as servant in name is a corporation without regard to how any item, idiom sonum, name is styled or annotated in any complaint or form. Federal Rules Evidence, Rule 301, Agreement by Acquiescence. Rule 301 of the Federal Rules of Evidence states a presumption imposes on the party against whom it is directed the burden of proof, see 556D, of going forward with evidence to rebut or meet the presumption. When the complaint is lodged by the government for a fine, fee, or tax, all of which are revenue, they are imposed only on corporations. See Colonial Pipeline Co. versus Triangle, 421 U.S. 100, 1975. Thus, this instant complaint for the collection of some form of tax must have lodged against a corporation whose name is similar to my name. This respondent must rebut the presumption that this respondent is the corporation named in the alleged complaint. If the respondent is not a corporation, he cannot appear and plead. See West Union Telco versus Isley 2 COLO. 141 Greenwood versus Railroad Co. and Massachusetts 32. Foster versus White Cloud. Hobbits versus Folger. Boyce versus Church. Folsom versus Star Union Freight Line, 54 Iowa 490. When a party brought into court by its corporate name, its existence as a corporation is admitted, see Mud Creek Drain Co. versus State, 43 IND 157. There's a number of other cases to support it. I'm not going to read them all off. Stating no facts but conclusions only is sufficient. It has been held that where the representative of the railroad corporation is served with process, he may plead in abatement in his own name that the corporation is extinct. See Kelly versus Railroad Co. Flip CC 581. Callender versus Pennsylvania Co. 11 Ohio Stat ST 516. I'm not going to read all those court cases again. Mies and West 149. Where the person is so served with that he may be, by plea, deny that she sustains any such relation to the corporation that authorizes this service of process on him or her. See Kelly versus Railroad. In 1886, the Supreme Court did not grant corporate personhood to any state of the Union or federal government, and that this doctrine derives from a mistaken interpretation of a Supreme Court reporter's notes. See Santa Clara County versus Southern Pacific Railroad, 118 U.S. 394, 1886. No laws were passed by Congress granting that corporations should be treated the same under the Constitution as living, breathing human beings. And none have been passed since then, ladies and gentlemen. No court decision, state or federal, hold that corporations were persons instead of artificial persons. The Supreme Court did not rule in Santa Clara County versus Southern Pacific Railroad Company, 118 U.S. 394, 1886, in this case, or in any other case, on the issue of corporate personhood, as Railroad Attorney Saunders and his two colleagues watched Chief Justice Morrison Remick Waite told Delamas and his two colleagues, the attorney for the opposing party, that the court does not wish to hear argument on the question whether the provisions in the 14th Amendment to the Constitution, which forbids a state to deny to any person within its jurisdiction the equal protection of the law, applies to these corporations. We are of the opinion that it does. This written statement that corporations were persons rather than artificial persons with an equal footing under the Bill of Rights as humans was not a formal ruling of the court, but was reportedly a simple statement by the Chief Justice recorded by the court recorders, see Vermont Supreme Court Volume 118 of the United States Reports, case adjudged in the Supreme Court at October term 1885 and October term 1886, published in New York in 1886. by Banks and Brothers Publishers and written by J.C. Bancroft Davis, the Supreme Court's reporter. Here is the often expressed understanding from the United States Supreme Court that in common usage the term sovereign in statutes employing the term person and corporation are ordinarily construed to exclude the sovereign man or woman. Wilson versus Omaha Tribe, 442 U.S. 653, 667, 1979, quoting United States versus Copper Corp, 312 U.S. 600, 604, 1941. See also United States versus Mine Workers, 330 U.S. 258, 275, 1947. U.S. Supreme Court in Luther versus Borden, 48 U.S. 1, 12 LED, 581. The government are but trustees acting under derived authority and have no power to delegate that what is not delegated to them, but the people, as the original fountain, might take away what they have delegated and entrusted to whom they please. The sovereign in every state resides in the people of the state, and they may alter and change their form of government at their own pleasure. U.S. Supreme Court in Wilson versus Omaha Indian Tribe, 442 U.S. 653, 667, 1979. In common usage, the term person does not include the sovereign, and statutes employing the word are ordinarily construed to exclude it. Rebuttal presumptions are, in effect, inferences that in the absence of any controverting evidence, the jury is required to make and, in civil cases, to accept as established facts. 89 People versus Wong Sang Lung. Say that 3 times fast. 3 California 221, 84, page 843. Black's Law Dictionary, 6th edition, 1990, page 1267. Rebuttal presumption. In the law of evidence, a presumption which may be rebutted by evidence is otherwise called a disputable presumption, as species of legal presumption which hold good until evidence contrary to it is introduced. Beck versus Kansas City Public Service Co. Missouri Appellate Court, 48 SW2D 213 215. It shifts burden of proof. Heron versus Donna, 285 U.S. 312, 52 SCT 358 362 76 LED 772. It gives particular effect to certain group of facts in evidence, of facts in absence of further evidence, and presumption provides a prima facie based on the first impression accepted as correct until proven otherwise. Case which shifts to defendant the burden to go forward with evidence to contradict or rebut the facts presumed. Galea versus Boggs, FLA 174 SO 2D 26 and 28. Black's Law Dictionary, 6th edition, 1990, page 1185. Presumption. An inference in favor of a particular fact. A presumption is a rule of law, statutory or judicial, by which finding of basic fact gives rise to existing or presumed fact until presumption is rebutted. Van Wert versus Cook, Oklahoma Appellate Court, 557, page 2D, 1161, 1163, a legal device which operates in the absence of other proof to require that certain inferences be drawn from the available evidence. Port Terminal and Warehousing Co. versus John S. James Co. D.C. Georgia, 92 FRD 100 and 106. UCC subsection 1-206, presumption. Whenever the Uniform Commercial Code creates a presumption with respect to a fact or provides that a fact is presumed, the trier of the fact must find the existence of the fact unless and until evidence is introduced that supports a finding of its non-existence. https://www virtuallaunderwriter.co 13.00.2 Presumptions of Identity. A presumption is an assumption of fact that the law requires to be made from another fact or group of facts found or otherwise established in the action. A presumption is not evidence. A presumption is either a conclusive presumption or rebuttable. All punctuations herein is for emphasis, whether in conformity with Styles' manual or not. All time is now time, with all on a level plane. For I am with a divine right to determine words and their meanings. Now, and where required, clarified for conveying my intent, as I determine my intent best serves his divinely ordained purpose. He purposes for his live life that lives in I. I am, I am, in E-S-E, one body, soul, spirit, one divinely ordained tres fecitum, pronunciation, horrible, fecitum collegium, called by Christian name, Derek Chaton, one in the ancestral lineage in the particular house of Gonzalez, styled Derek Chaton Gonzalez, one created in the image of God, ordaining that I be one who does sojourn in this temporal realm, and I do asseverate that I am not, nor have I ever been, a corporate fiction of law, fictitious entity, corporate person, non-entity, legal entity, or surety for any civil mortis creating of the state. And I further asseverate that I am that I am that hath created, ordains this living man of male gender, is with grant of dominion, grant over the earth, and ordained by divine intervention. I do his will as he reveals himself to be, and by the grace of God, he ordained my American sovereign birthright nationality upon the soil, with Arizona, with its republic in administration by the state of Arizona, and I, Derek Chaton Gonzalez, as ass servant, reserve all rights, remedies, and defenses, waive none, and I, Derek Chaton Gonzalez, as ass servant, as servitor, waive all benefits without God, and I, Derek Chaton Gonzalez, as ass servitor, I bring the land, and I reserve the rights to alter, amend, or abolish any part or parcel or portion of this presentment as I deem fit or necessary to alter and amend or abolish without prejudice, prejudicing any other part or parcel or portion of this presentment. And I, Derek Chaton Gonzalez, as servant, have not seen any facts or evidence that the above enumerated presentments supported herewith are not true, correct, complete, without misrepresentation or omission, and I believe none exist. Thank you guys for joining me this morning. When we come back, we'll get back into the license grant deed. For now, I have some other things that I have to tend to, so we'll talk to you soon.